Welcome everyone to today's Pro to Know webinar series. My name is Sandra Vidrio and I'm the Business Development Officer for the Fresno Area Hispanic Foundation. On behalf of our team, I would like to say thank you for joining us this morning. Our guest speaker for today is Daryl J. Horowitz. He is Managing Partner at Coleman Horowitz, LLC, and we have the pleasure of joining him this morning. Before we get started, I would like to share with you a quick tutorial on using the Zoom chat feature. If you're accessing the webinar through a laptop or a desktop, you can locate this tool by selecting the chat icon. And if you're using a mobile device, please tap on the More option of your screen to access the chat feature. During the presentation, please submit your question through this tool, and we will monitor and address your comments, myself and Stephanie Dunn. And after the presentation, we will go to the Q&A session. And as you can see on the screen, our agenda for today is the following. We will be sharing briefly about the Fresno Area Hispanic Foundation and then transition to our guest speaker, followed by the Q&A session. The Fresno Area Hispanic Foundation is a nonprofit organization with the mission to promote education and self-sufficiency. The three core programs offered at the Hispanic Foundation include our Technical Assistance Program, Microloan Program, and Downtown Business Hub. Our bilingual incubator is located in downtown Fresno and is equipped to offer office space for startup and existing businesses, in addition to conference and training facilities. We assist individuals that are looking to start a business or expand their business by providing them with the tools, educational training, and resources for business growth. At the moment, our team is staying informed with our business community by sharing up-to-date resources and hosting weekly webinars on relevant topics related to COVID-19. Please feel free to reach out for assistance by calling our team at 559-222-8705. And I also want to share about Womanpreneur, an online program that will be starting next week on May 12th. And participants will have access to 8 virtual marketing workshops and also create their own strategy plan to have an online marketing presence. The best part about this program is that it will be offered at no cost. Thank you to our generous sponsors, and we're still accepting businesses that would like to be a part of the program. If you're interested in participating, please send us an email at incubator@fresnodvh.org. That way we can send over the registration link and also answer any questions that you may have. Once again, we're still accepting businesses to participate in this program. And with that, I would now like to introduce you to our guest speaker, Daryl Horowitz, who will be sharing some information with our business community on how to protect their business.
Hi there. Can everybody hear me? Hello?
Yes.
Okay, great. All right, this is Daryl Horowitz. Thank you so much for giving me the opportunity to talk to you. I have with me, although she's not on the sign-up information, Stephanie Dunn, who's an associate of our office. And Coleman Horowitz is a law firm in Fresno with offices in Sonora, Fresno, Visalia, Bakersfield, and Los Angeles. And we represent businesses and their owners. And since COVID-19 came on the scene, we have felt a desire to provide information to everybody about how they can do better with COVID-19. And so we have written articles, and if you go to our website, ch-law.com, you'll see articles that might be able to help you. And when the Hispanic Foundation reached out and asked me how we might be able to help, I realized there are 4 main areas that business owners would like to know about. If you have questions as we go on, please use the chat feature to do that, and Stephanie and I will be looking on. But the topics really are, what are courts doing with COVID-19? And how is that going to affect you if you're in litigation? What restrictions are there on leases now that might help you or hurt you? Are there any emergency rules that have come into place? And what other issues have come up? And we have force majeure on there as one of the topics, which is a term that means circumstances outside of your control that may prevent you from performing your contract that we'll talk about. There may seem like a lot of information. I'm not trying to feed you information as if you're drinking from a fire hose, but there is a lot of information. We'll try and go through it. and then we'll stop at the end so you can ask questions as we move along. And so let's talk about first on the COVID-19 court update. Courts are particularly susceptible to the transmission of any infectious disease, and COVID-19 is highly infectious. So as soon as it was known how infectious COVID-19 was, courts started closing down. As they were closing down to the public, and they realized that certain technologies existed that everybody else was using, but courts weren't, that could possibly help you get the job of the court system done. And one of them was realizing the telephonic communications or hearings and video conferencing was going to be available for courts. It took them time, however, to do anything about it because courts move slowly. And if anybody's been in a lawsuit, you would know that the court systems move with the speed of a glacier. So getting changes done and getting the courts to do anything took several weeks, but they did act. So the Supreme Court has worked with all the local state courts to issue some emergency rules, and here are some that will affect you and your business, depending on how it works. First, unlawful detainer actions. Those are if you have to remove somebody from real property, is an unlawful detainer action. Absent the safety and health of the community being impacted. For example, having somebody who's using your house as a grow lab, cooking meth, things like that, where you have to kick people out because of or they're hoarders and it's just an unsafe condition. Absent something like that, any attempts to try and kick somebody out of their residence is going to be stopped. And you are not going to even be able to file an unlawful detainer action. And this is really hard because there are really bad tenants out there and they aren't paying. And the people who own the property still have mortgages to pay. And where are they going to get the money from if they can't enforce the obligation to pay? But the fact is, the courts realize that a lot of working class people like you and me, and I do work for a living, need some respite now. If we aren't getting paid because we may be laid off, and fortunately Stephanie and I aren't, but if we were laid off, how are we going to pay for rent? And that's one of the rules. The other emergency rules are foreclosures. If you aren't paying for your house, the banks can try and foreclose your house. And that rule now is stayed. You cannot file a foreclosure unless it's necessary for the health and safety of the public. And that will happen from time to time, but unlikely. It's gotten so bad that the courts will not even allow you to file a lawsuit for unlawful detainer or a foreclosure while this pandemic is going on. And they're talking about, but good news. Normally you would have a limited period of time to sue on a foreclosure or to take steps on a foreclosure. And those times have now been extended, what are called statutes of limitation. And any time a lawyer uses the term statute of limitations, it means the time within which we have to file a lawsuit. So those are being extended, okay? Another emergency rule is allowing remote appearances, okay? Some of you have been in a lawsuit before. I hope you haven't, but some of you have. And you know that you have a right to take a deposition, or there are court hearings, like a case management conference, where the court just wants to see you and say, we're going to set a trial date. Well, before you'd have to go to court, or you'd have to go personally to a deposition. You go, well, why would I have to get out of my house to go to a deposition in Bakersfield when I'm being sued, when I'm in Fresno and I can't leave the house? How is that going to work? So the courts have now said, wait a minute, we aren't going to force you to go anywhere. We're going to allow for remote depositions and remote appearances using video technology like Zoom, like WebEx, GoToMeeting, anything along those lines. They're all using them now. And court reporting services are now getting very good at it, where you can actually show documents to the people in exhibits. But now you're going to be able to do that. Now you're going to be able to actually start having court hearings by remote. And by the way, for people who are saying, well, how does that help me? Well, boy, it saves you a lot of money now if you have to hire a lawyer. There's a question that's posed. Article 3 clearly states the authority, state law gives the governor in a state of emergency. Closing and opening businesses are not on the list. Neither is wearing masks or requiring any shelter in place. No state law allows the governor authority over anything but dealing with state employees, budget authority, and state buildings. It would be nice, and thank you very much for that question. It would be nice if that were true. And there were limited, and everybody had a nice little cubby hole where you have the authority to do this and you have the authority to do that. However, state law has changed over time. Just to answer this question a little bit out of order, state law has changed over time where cases have determined, do governors have executive authority as leaders of the executive branch to issue orders, including stay-at-home orders where it's necessary to preserve the public safety and avoid having to go to court to force everybody to do that. And over time, the fact is, there's case authority that says the governor does have that authority. For example, for those out there who don't think they do, churches have already sued to be able to reopen in California. There was a lawsuit. They filed them in federal court. And they filed a lawsuit already in Sacramento, and a judge has already determined based on the briefing, and there was extensive briefing by both sides, that the governor does have that authority. So if you think that the governor cannot impose emergency regulations, they can. Are they more in the guide? But enforcing them is another thing. It ultimately has to come down to local enforcement. And you may have seen that in Clovis. They say we just aren't going to enforce these laws. The fact is, the governor has the right to call out the National Guard. The governor is the commander-in-chief of our National Guard at all times. So if necessary, the governor has the right to enforce those laws by calling out the National Guard. It's unlikely that'll happen. And fortunately, for anybody who's concerned, you'll see that by Friday, the governor is already thinking about lifting some of those rules. Moving on, though, to this, and thank you for the question again. Moving on, Emergency Rule 8, extensions on temporary protective orders. So this has changed now. On April 23rd, the court issued another order, and I'll clarify that. But on this one, you go into court, you have a neighbor harassing you, and you need a temporary restraining order to get them to stop. Or you have a spouse or an ex boyfriend or girlfriend who's harassing you. You have a right to go in for what's called a temporary restraining or protective order. And under this rule, normally those last only 20 days. Now the court's saying it will last a longer period of time until the emergency is lifted. I will tell you that on April 23rd, the court came out with additional rules to modify Rule 8 to say the courts are now empowered to set up hearings telephonically or by video conference to allow the orders to be extended or a permanent injunction to be granted. So those of you who are concerned, and this includes employees within your business, you have employees harassing others and you fired them and they want to come back, you have a right to get a restraining order or protective order for them. Those are still going through. Emergency Rule 9 is very important on the tolling of the statute of limitations. And the statute of limitations is now being extended to 90 days after the governor lists his emergency order. And we moved a little bit fast there. On Emergency Rule 10, it's extending the statute of limitations on cases. Most people don't know this, but I'm a trial lawyer, and if you serve a lawsuit, but you don't do anything for 3 years, I have a right to file a motion to get the lawsuit thrown out for failure to prosecute. If it's not brought to trial within 5 years after you serve, it's required that the lawsuit be dismissed. And sometimes that happens for lazy people, and I use that to protect our clients. So, but the courts have now said those time periods are now going to be extended by the emergency rules. By the way, on this, somebody, Abraham, thank you. Can we get a copy of this PowerPoint? I think that this will be recorded later, so you can get it from the Hispanic Foundation. Whether it will be posted on their website, we'll leave that to them. And then for articles that cover these same subjects, you can go on to ch-law.com and look at the COVID-19 articles, and you can download the articles from there. They're free of charge. Or what I
Correct.
say.
Yeah, and if I can add to that, please send me an email to the FAHF via the chat to FAHF. That way we can have your email on file and make sure you receive a copy of this recorded webinar. Thank you.
And as I mentioned, the articles are free, which means they're worth every cent you pay for them. Hopefully they're a little bit more informed than that. Moving on, we already talked about this. Video depositions are now permitted. Before we'd have to ask for permission. Now we're just telling people this is going to be by video and you have no choice on it. Another rule on the, there's one other rule that's important now on the video depositions. What's really good at coming about this, and Stephanie could talk to it maybe hopefully in just a minute, but one of the nice things is all these different ways to do business for lawyers are really going to save you money in the long run, because especially the younger lawyers are going to get to use this and be comfortable with it. Any mediation now can be done by video. So if you have to sue somebody in another state and you want to mediate, it could be that this could be done by video anyway. And as your business grows, that may be an issue. Let's move on to another issue, which is not people calling me on my phone and making a lot of noise. And by the way, Stephanie, you have anything to add on the emergency rules before I move on? I'll take that as a no. So let's talk about additional funding for small businesses. The first program is the Payroll Protection Act, Payroll Protection Program. You've heard a lot about it. Under the CARES Act, they've set up a loan program where with the payroll protection, you can qualify for a loan if you're 500 employees or fewer, unless you meet certain requirements. It could be more employees. There was a significant amount included at the original amount. It was 394 billion was originally. It was exhausted in 2 weeks. But the way it's designed is, and it was pretty clever, if you got the loan and used it within 8 weeks of the time that you received it and used it for payroll purposes, okay, and certain rent in the proportion allowed by the act, and there's been a nice chart here. Thank you, Stephanie, for putting it on there. That's important. If you used it for that purpose, then the loan, you wouldn't have to pay back the loan. And the beauty of this is that, let's say you run a restaurant and your employees are home now. So you'd have to lay them off and they have to go on unemployment. That gets charged to your unemployment insurance. And you have to replenish that over time. But that gets charged to unemployment. Here, if you kept them on and used the payroll protection plan program funds for that, they don't have to go on unemployment. Even though they don't even have to work. Okay? But there was money available, and that would have saved money on the unemployment insurance program. The way that the federal government rolled it out kind of flummoxed people, made it really hard for people to figure out what to use the money for. And I've seen articles saying, well, I run a restaurant, what do I do? Because I had to lay these people off. Well, it's to bring them back and pay them during that period of time. So you can get through the bump. And if it's forgiven and you have any other money, now when the restaurants reopen, you're ready to go. So, and then there's also the CARES Act, which is the Coronavirus Aid, Relief, and Economic Security Act, which is going to provide additional funding, which is an economic impact disaster loan, which can be requested in addition. And there's an economic disaster injury loan, I'm sorry. And you'll see it that it's a very low cost loan. It can be paid off over time, and you can ask for an addition to the PPP loans. So these are meant to be stacked. And then if you have a larger business, there's going to be additional funding through the Main Street Loan Program, which is going to be run by the Federal Reserve for larger amounts of money. And the idea is you can, on the short term, you won't have to close because of the PPP money. For long term, you can use the EIDL funds. Under the original act, there was other economic injury loans that you could apply for. And on one of them, if you applied, and even if you were rejected, you would get $10,000 for the emergency loans. It turns out people applied for them and they never got the $10,000. Somebody was nice enough to write to everybody. Please see Elaine's comments yesterday about transportation included under the 25% available, which is important. Thank you very much for that. On additional funding for small businesses under the Act, this is causing some concern. We're getting phone calls on this. And what was happening is that when you get an SBA loan, and an SBA loan just means the SBA is guaranteeing the loan to the bank so that if you default, I don't know how many times I have to shut this on Do Not Disturb or that there should be no ringtone, but people really want to talk to me, I guess. Sorry. Generally for an SBA loan, you have to certify you can't get funds elsewhere. On the PPP loan, you don't have to make that certification, but you do have to certify that based on the current economic uncertainty, that you have to, the certification will say the current economic uncertainty makes this loan necessary to support ongoing operations on your account. And that means the bank doesn't have to look into whether or not you would normally qualify for a PPP loan. Companies, very large publicly traded companies, people with access to capital, and they can issue stocks and bonds. We're getting PPP money like Steak Shack, the Lakers, who, because I grew up in LA, I follow the Lakers, so I think they deserve the money. But the Lakers got money, and they realized, how are you going to say the current economic uncertainty means that makes this loan unnecessary when a billionaire owns your business, or billionaires know it, and you can survive this? So they started giving, and I think over $2 billion has already been repaid. For the smaller business, what does this mean? What if you had money in the bank? What if you had a line of credit already? What are you supposed to do? Is the SBA going to come after you? The answer is we don't know. When they realized that people were abusing the program, they issued what are called FAQs, frequently asked questions. And one of them was that they're going to audit everybody who had received over 2 million. And so I said a prayer, thank you. I didn't get that, our firm didn't get that much money, but they still may audit other companies that can't show it. If you had $1 million or $2 million in the bank, already had $1 million line of credit, you have a rich owner, and you're a sole business, to get a PPP loan for your staff, maybe it's an issue. The only thing I can say is if you're concerned about your current circumstance, talk to your lawyer and or accountant. Before we go on to the next slide, Elaine's also had a question. Is there any clarifications whether mileage, gas, vehicle payments, insurance are included? I can't answer that. I looked through the FAQs and the answer was not there. In all likelihood, if it's going to be transportation, the cost of the transportation altogether might be included. But I would talk to your accountant and I would talk to your administrator, because normally the biggest expense that you have that you can repay through the PPP are employee costs, and you're going to be able to do that under the PPP. And you have to look at using those funds for that purpose first, and then your rent and utilities second, and then you can look at, is there any money available for other things within that 8-week period? And if you have to use it up for those, then maybe you should talk to your lawyer or accountant about whether you can then throw in those expenses. So we've talked about the certifications. Just think about the status of your business. If you have access to other funds, you might want to look into them. Or Or if you have a written analysis that you made before you even looked into it as far as why you need the PPP funds and what you're going to use it for, by all means, save it. That will help you. The PPP loans were available, ran out of money. They're not taking more applications. They're talking about even a third round of funding. If you don't have your application in yet, please do so. And if you don't have a bank to run it through, now's the time to get that relationship. Now's the time to look at, I need a banker. This emergency's given me some concern that I don't just want to be able to deposit checks. I need to have a relationship with a banker. So I'd urge everybody out there, think about your banking relationship. Who do you talk to when you really need help like this? And if you don't know, now's the time to think about creating that relationship. And that includes the sponsors, people who work closely with the Hispanic Foundation. They can also refer you to banks that they have comfort with, especially those who support the businesses that are members of the foundation. Again, if you previously submitted an application, didn't receive a response, check in. You shouldn't have to refile it, but you may have to redo it at another bank. The terms are great. You can use it for payroll, employee salaries, mortgage interest, rent, and utilities, and interest on debt. The amount you can get is 2.5 times your business's average monthly payroll. The interest rate's fixed at 1%. Yet don't have to pay payments for 6 months, but part of it may be forgiven if you use it, and that's if it's approved. Now, we're moving through this quickly, maybe a little bit too quickly, but we do have Governor Newsom did issue some orders that are helpful to you. So I realize that some people may be concerned that the governor is exceeding his authority under Article 3 of the state constitution, but one of the protections is consumer protection. And recently, the governor issued an order that says that if you have funds from the CARES Act, you got a PPP loan, you got an emergency loan from the federal government, but somebody had sued you and you have a judgment against you, they cannot levy on those funds. Okay? If you owe child support, spouse support, family support, or criminal restitution, they can go for those funds, which could be a detriment to you. But anything else, a regular judgment against you for a business debt, they can't go after those funds, so they're protected in some respects. And if there is a wrongful attachment or levy, you have a remedy now against that, which is a wrongful levy. There's a lawsuit that's available. So keep that in mind. Now, if you're aggressively trying to collect the debt that's owed to you and they get this windfall, you can't use it for that purpose, but you may realize now's a good time to go into their bank account because they have other monies that they're squirreling away for later that you might be able to go after. All this can be important. You know, we're a litigation firm, and this is what we do every day. And going back to this, one of the reasons this can be important to a lot of you is because your business isn't stopping because COVID is going on. Period. I mean, what are you supposed to do? You can't go outside, but your business doesn't stop. If you have contracts, those contracts still need to be prepared and signed. If you have a lawsuit, you may have to file it to get the people's attention. Those need to be done. Now, what's not on our PowerPoint, though, is you have other ways to try and get your disputes resolved. And that includes arbitration now and mediation. And with everybody at home and remote technologies available, as long as you're staying home maybe through the end of May, in order to get money into your business, now may be a good time to tell your lawyers, hey, now's a good time to mediate. Let's move this along. I don't have to wait till June. All right, so we have another question. Stephanie, you have anything to add? Is her line unmuted? Or did she abandon me?
I think she might be muted. Let me try and figure out if I can, oops, go back to the other slide.
Well, let me read the question while we're there. Oh, she says, I can't unmute. That means that the controller on the foundation has to unmute. So going on to this question, we're a small business, 3 employees. You're 6 inches tall. That is a small business. 3 employees that include me. I just received email from my bank. The application was denied because unable to verify average monthly payroll. I am not on the payroll, but I get my pay from my business. Are there any other alternatives? The answer is yes, but it requires you working with your accountant. There is a way to verify your payroll. There is a way to verify your books, but it determines on what you're going to have to look at is how have you been characterizing how you're paying yourself. And we're a partnership, Coleman and Horowitz. That means that as a partner, I don't get a salary, I get a draw. And how do you prove that I'm getting money except I get a distribution of profits? That's all I'm supposed to get. Is the way we do it is every month when I get paid, we identify that this is a payment to the partners similar to salary so we can track it. If you've been receiving, if you're a sole proprietorship and you have where you are not technically an employee, but you're pulling out money, talk to your accountant about a way to characterize it where you can track on payroll how you're getting paid. Also, for now and in the future, realize if you're getting a regular distribution from your business, even for a few thousand a month, you may want to run that through your payroll service where there is no deduction for you, but there may be a deduction for your employees. And that may help you be able to identify. It'll be easier to verify your average monthly payroll costs from that information. It's the way you've characterized it beforehand. If you recharacterize it and resubmit it, that may help. So talk to an accountant about it.
Can you hear me?
Yes, I can now.
Oh, great. I was going to say this brings up another point I was going to try to make earlier is what documents should businesses be preparing if they want to apply for the PPP loan? What should they be making sure their documents say in order for it to be approved?
Well, that's a good question that I'll let you answer, but no. Okay, I'm just going to keep scrolling on these things to avoid the question. But basically, the banks are going to have, each bank is going to have their own requirement based on their understanding of how to submit the loan application. But for a lot of businesses, there's a payroll report that comes out from an independent payroll service or from your payroll accounting program that you use internally on your computers. That's going to have to be there. In all likelihood, your tax returns are going to show money that is paid as salaries and distributions to shareholders. And that those tax returns may have that information on it. From a partnership, we had to show what our average returns were for last year to prove for this year and whether they were consistent. So we had to use what is a partnership tax return in order to do that. So those are some of the documents. For some people, they may have an internal report. If they use QuickBooks or some other accounting program, that's going to the general ledger may be necessary in order to submit the loan application. If we have anybody from a bank on the line who can answer as well what they've seen needed to be put in, please share the information. You have anything you want to add on that, Stephanie, as far as what you've seen and being submitted?
No, I think you answered pretty well.
Okay, we had another question. It says, and this is from Yuri, says, just to clarify, business owners can be evicted from their place of business for non-payment even though they were impacted by COVID-19. we're reading it that, and thank you for the question, we're reading it that nobody can be evicted, residential or business, during COVID-19. Okay? And so no evictions are going to happen unless it's for the safety or health. And it also depends on what was happening within the business. I can guarantee you that if somebody is running an illegal operation, it'll be shut down faster than anything, and there's no restriction. But right now, if you came to us and said, my tenant is not paying, they're saying COVID-19 has prevented them from paying, I need to get them out there because I've got a tenant who wants to move in, what can I do? I'm going to have to tell them, I'm sorry, the court will not even let me file a lawsuit. They just won't. And we file electronically now. And they also have a drop box at most courthouses, and we could drop it in the box. They won't return it. They'll just reject it. Okay. I will tell you that there's one other restriction now that has come up in the state courts. Yesterday, 2 employees reported that they were in contact with somebody who had COVID-19. As a result, the entire civil courthouse in Fresno County has been closed. Interestingly, Kern County's courthouse is starting to reopen. So as of this week, the probate court and the family law court are actually having hearings in person. I will also tell you federal courts are closed to the public, but they're having matters heard on a regular basis. And for those who don't know the difference, there's a federal court that deals with certain civil matters over $75,000 of people between different states, or where a federal law allows you to file in the courts to recover money, or where the U.S. is a party to the lawsuit or in federal courts. In those courts, if you file a lawsuit, they'll accept them, and if you file a motion, they'll decide them. But before COVID-19, they weren't really having oral argument anyway. You'd file your paperwork and they'd give you a ruling on it, and they're still doing that. So, but just no personal appearances, and they're going to start having video appearances. And Carlos, thank you. Carlos Galvan says, I've helped businesses apply for the PPP and receive the loan. Every loan officer is different. God bless them. That makes it so easy to figure out. But you're right. Every loan officer is different, but every bank has a set of procedures. That's why having a bank relationship is so important. Let's move on to what this term is, force majeure. So COVID-19, you're running a business, you have an order to provide something other than COVID-19 related materials. Your customer is wondering when you're going to supply. Let's say you supply books, that you're supposed to print so many books, but you can't get paper because the paper suppliers in China and they've been shut down. What are you supposed to do? You're a contractor, your employees can't show up to the job site because there's a stay-at-home order. What are you supposed to do? Well, it depends on what your contract says. Most contracts, if you've seen them, they're long. And you've heard people talk on TV. There's a lot of boilerplate. The boilerplate are standard terms that are in almost every contract. That's what boilerplate means. And you're right, there's standard language in almost every contract. One of those standard provisions is one, you wonder why it's in there. It's called force majeure. It says, in the event that certain unforeseen circumstances arise that prevent you from fulfilling the terms of the contract, you may be excused. So you're a landlord. You've leased out property under an agreement that has a force majeure clause. And one of the areas identified is riots. And your lease says that if a riot causes the building to be burned down or a hurricane destroys the building, you still have an obligation to pay rent, but we have a right to go fix the building if it's not more than 50% destroyed. Or a clause will say, if you may have a clause in a manufacturing contract with China where it says or in your manufacturing contract, that if there are certain events that arise like war, riots, natural disaster, earthquakes, typhoons, hurricanes, or such other events that are unforeseeable and unavoidable, you may be relieved under your obligation to fulfill the contract. That's good news for you. That means that they can't sue you for breach of contract. Well, that means that if they sue you for breach of contract, you have a defense. And that can be really important to you, depending on what type of business you do. Imagine you've been hired as a framing contractor to go out there to frame an apartment building. And the governor says contractors are not exempt. They are not an essential service. They are now, and they always were. But let's say they didn't say it. And what you would do is say, what does my contract say? And it may say that if there's a government order preventing you from doing your job, or if just a basic force majeure clause that says any act which prevents you from doing your job, you're relieved from it. That's not unforeseen. So rain, you're still stuck. But the governor telling you to stay home, that relieves you from it. You want to look at your contract if you have that circumstance. Also, if you're waiting for somebody to perform and they aren't, and the COVID-19, they're arguing COVID-19 covers them when it really doesn't, take a look at your contract because it may be something that you need to look at. Again, the events must be unforeseeable and unavoidable and not a result of your actions. In other words, you can't fire everybody and then say, I've got no employees now. They should be considered acts of God. Sometimes acts of God you might even have unforeseen communicable infectious diseases. Normally you don't have it. But typical events that can trigger are unpredictable natural disasters. So when you had the tsunamis in the Southeast Asia, earthquakes, floods, we've had wildfires in Northern California the past few years that have prevented companies from. Please be aware of this because this could impact your business. I also believe that one of my areas of practice is construction law and real estate law. In real estate law, if you're a realtor, you know that the California Association of Realtors has brand new forms that everybody's got to sign. It says that if the buyer cannot come up with a loan because nobody's in business, nobody's open, and COVID-19 is preventing this, the whole deal can be unwound. On construction companies, you still have a start date and a stop date, but because your employees are fearful of getting COVID-19 or have taken leave because they have to care for somebody with COVID-19, and you don't have the employees, you now have to take affirmative steps to try and protect yourself. Yeah, and this is important. Mind you, there was a Families First Response Act, part of the initial COVID relief. And although it's not in the PowerPoint slide deck here, one of the things, one of the provisions was that there's an article on our website, please go to it if you'd like to find out more, because this really impacts your business. If you have fewer than 50 employees and they would normally not be entitled to the family medical leave provisions, the federal government now has given anybody who has COVID-19 or believes they do, they haven't been tested, but they have all the symptoms and they had to go home. They have up to 12 weeks of leave. For a full-time employee, I believe it's up to 80 hours of their full-time pay. And for a part-time employee, it's 2/3 of their average part-time hours. And that's important because they get this money and the employer pays for it. And they have a right to take this leave. However, if they do take the leave, you're entitled to a credit on the Social Security and Medicare tax you would normally pay in. And you can offset that, the amount you're paying your employee for the leave, for the emergency leave, and offset it up to the amount that you're actually paying them. You can't take more than that. by the way, Raina, thank you for your comment. It would be good if anybody has a sample payroll or optional formats that's an accountant for sole proprietors, please get in touch with the foundation, and maybe Yuri can or Sandra can post it on their website, or links to samples that people can look at from an accounting standpoint. As lawyers, we went in to be lawyers because we aren't good with numbers like accountants. No, it's very important to be able to do that. So there may be some forms, and if you have it, please take a moment to provide them. So what if you can't perform your contract? What should you do after you stop panicking? First, review the contract, see if it includes such a clause. If it does, review what the specific language is, because everybody's language. Things that include terms like epidemic, pandemic, public health emergency are good. If it doesn't, talk to your lawyer about whether it's broad enough. And here's the other key that is non-legal. Talk to the person that's being affected by the shutdown. Talk to your customers immediately. There's no guarantee that they'll be very receptive to being told you can't perform, but they're probably in the same boat. And if you don't tell them, the reason, let me back up. If you don't tell them, that's what helps cause lawsuits to be filed, the lack of communication. And people say that they come in and they say, I've just been sued, I can't believe it. We talk to them and say, well, did you talk to them? And say, immediately, as soon as you found out you couldn't perform because of something caused by COVID-19, did you talk to them and ask them and tell them, I'm going to have problems here, so that if they need to go to a different supplier, they can? Did you talk? Oh no, I felt too embarrassed, or I tried to tell them and they were just really rude, whatever. That's how lawsuits get started. I'm not saying we're going to guarantee that you won't have a lawsuit if you call your customer, or if you call your supplier, but it will help start the communication process on how you can solve the problem. You don't want a lawyer to solve the problem in the courthouse. You want to do it yourself before you ever see me or Stephanie on that. So what if your contract does have a force majeure clause? Well, you can at least bring it up to your customer or supplier and say, look, we can't do these things, and here's the contract provision that I'm relying on. What can we do to help you with this? We're all in this boat together. And again, we can't prevent somebody from suing you, but we have you put these provisions in the contract to prevent you from being sued, or that we have a defense. My grandmother had a saying, and if you've heard me speak before, you've heard it. If you haven't, I'll say it for you. My grandmother used to say, if I knew I was going to fall, I would put down a pillow. And lawyers are the pillows that people sometimes need before a problem develops. But let's look at what this slide says, because it is important. Even without a force majeure clause, you may be able to still be excused if it's impossible to perform, because there are defenses called impossibility of performance, also one called frustration of performance. So there are defenses you have, and getting out in front of them is really important. There are other reasons you may not be able to perform, like a supervening event. Those are on an individual basis. We talked about frustration of performance, but basically something else or somebody else is preventing you from doing your job. You needed to get, you assemble books. You're a Yellow Page company, but the paper hasn't come in, and you print the books for the Yellow Page company. If you don't have paper, you can't print the books. And if you don't have paper because everybody's gone home from the other place and they're shut down, you have to go up the stream. So whatever it is preventing you. People who are in the construction business get a lot of their materials from China. If China's shut down, you can't get your materials from them, especially steel and some other building materials. You just can't build the project. There are other businesses that have the same issue. Just be aware of that. Again, contact your customer, and don't know why the printing looks different, but what I was going to say is, and do it in writing. Do it by a phone call first, but follow up in writing. Whatever you do before you go see a lawyer about everything, make sure you have something in writing that follows the path of what you've tried to do to avoid these issues. And the reason I say that is I have a saying that I use at work, and sometimes I'm sure everybody's tired of hearing it. If it's not in writing, it didn't happen. So before you go to a lawyer, make sure that you have your attempts to try and resolve these issues in writing. If you have health and safety issues for your tenancy and you really want to get them out, get that in writing to prove that, things along those lines, because that's helpful to us and it's going to be necessary on that. I went through this pretty quick so we'd have some time for me to answer any more questions or to finish early because it's almost lunch. And if you're like me, you're hungry right now. But my email address is on this website packet. I am working 24/7, it seems. Stephanie and I will be able to get back to you promptly if you have any questions. There's no charge for doing so. And also remember to go to your lawyer if you have a question that was triggered by this. So Carlos Galvan also has a question. So I have a question for a friend. Okay, if you say so, it's a friend. Would you suggest if they can't pay rent, but the landlord has threatened to kick her out of the office? I think the question is, should you pay the rent if you can't? First of all, the threats of the landlord, in terms of a lawsuit, are empty. They can't do it because you can't pay. They just won't accept the lawsuit. The landlord may change the locks, thinking that they're going to take the law in their own hands. The law says you cannot throw people out by changing the locks. The only way you can do that is by filing a lawsuit. Some landlords don't know that, or they want to ignore it, and they'll change the locks. If they do that, that gives the tenant the right to sue the landlord. Now the shoe's on the other foot. And that gives the tenant the right to sue the landlord for what's called forcible detainer, including all the damages that the tenant has suffered as a result of not being able to get into their property. So there are rights both sides have. And during COVID-19, I understand not getting rent for 30 days or so is going to be a big deal. But even so, I don't even know if they can try and do a 3-day notice to pay rent or quit. But I don't know that I think that there's going to be remedial statutes that are going to give some respite and allow people to pay the back rent. And by the way, if you are a commercial tenant, there is a law that says that if the landlord went out there and got a judgment against you to throw you out of the property, you actually have, and they actually got an order to remove you. There's actually a motion you can file where you offer to pay all the back rent. And the court, if they determine that is the entire amount of rent that you owed, then the landlord has to let you back in the property. So it's a motion for relief from the unlawful detainer proceeding that is only available for commercial tenancies. So with that, we're at 10:56. I'd like to thank everybody for your time. Stephanie, you want to add anything before Yerdy or Sandra have anything to say in closing?
I just wanted to add in regard to the force majeure clauses, even if you don't have one in your contract now, it's always something to think about for future contracts now that it's, kind of in your mind. Make sure that you have in the future, especially since people are saying this might come back in the fall and we don't know what's going to happen. It's always better to be safe.
Absolutely right. That's your pillow for the future.
Oh.
Well, thank you, Yerdy or Sandra.
Yes, thank you. Thank you so much, Daryl and Stephanie, for providing this valuable webinar to our small business community. And as mentioned, this webinar is currently being recorded, and so we will make sure to share a presentation copy to everyone. And with that, I would like to quickly mention the webinars that we have coming up. Tomorrow, we're going to be hosting a Spanish virtual workshop put on behalf with Noemi Chavez from Chavez Web Design, and she will be sharing some tips and advice on how to promote your business online. And on Thursday, May 14 at 1 p.m., we will be having Casey Curtin from Sandler Training provide an interactive presentation focused on overcoming obstacles to conduct sales even during difficult economic situations like COVID-19. And to sign up for these no-cost webinars, you can visit our website at freshnewaahs.org/events. And with that, I want to say thank you, everyone, for joining us this morning.